Hi everyone, my name is Marun Nassar. I'm known to be fearless, but when I first recorded my voice on this presentation, I got petrified. I thought that's it, I just lost half of my audience. But as you know, there's no way out of it. So today I'm presenting Chapter 3 and we will take a tour around the world to understand the history of mediation and how it evolved over time. So in order to understand the importance of mediation around the world, we will discuss the outline of our cultural mediation introductions. And I say introductions because no matter how much we talk about cultures and mediations around the country, there will be still more to discuss. First, we will start with the conflicts and mediation in every culture around the world, so a general overview, and then we will move to the historical and cultural roots of mediation, religious and customary practice. And then we will talk about the most important part, which is the contemporary practice of mediation. We'll talk about the Americas, mainly the USA, and a little bit about Canada, and then the rest of the world, starting from Africa, and then moving to Asia, Europe, Latin America, Middle East, and at the end we will finish with Oceania Pacific region. Move to the next slide. Before we start, I would like to quote Abraham Lincoln. He said, "Discourage litigation, persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often the real loser in fees, expenses, and waste of time." Mediation has a history in every culture in the world. In some societies more than others, the mediators could be a relative or a friend. If the dispute is serious, often more authoritative figures are involved: religious leaders, social leaders, chiefs, brokers, and so on. In developed countries, mediation has developed as an independent service and profession. Historical and cultural roots of mediation, religious and customary practices. Mediation in many societies is influenced by religion and local cultural practices. The ultimate goal would be to help people reach voluntary agreement. However, in many customary and religious processes, third parties may have also authority granted to them by their position, communities, institutions, or government, to make recommendations or binding decisions on issues of merit, claims, and settlements. Rabbinical courts played vital roles in mediating disputes between members of the Jewish faith. The clergy in Christianity played the role of mediator between individuals, religious congregations, and God, and between believers. The Islamic world, due to the nature of the Sharia, din wa dunya, the society relies strongly on the religious leaders, the sheikh, to lead the mediation, wisata, and musalaha. Other respected elected leaders, such as the mukhtar, or mayor in English, could as well be mediators, or more formal forms of mediation could be led by the qadi or judge. House to the largest Islamic population, Indonesia, followed by Pakistan, used the musawara and mufakat, deliberation and consensus. Mainly observed in villages where religion plays a stronger role. In Asia, Buddhist sacred texts described at least 3 cases in which the Buddha acted as mediator. Many villages in India have traditionally employed some version of the current panchayat justice system, in which a panel of community members both mediates and arbitrates disputes. China, Taiwan, Malaysia, Singapore, Japan, and Korea have long practiced mediation using respected members of communities or local officials as mediators. The Maori used rituals invoking spirits, ancestors, and common bonds to create an atmosphere for dialogue, open discussions without limits. In Melanesia, villagers have counselors and committees that meet regularly to hear disputes and allow parties to discuss freely and settle consensus. In many areas of Africa, customary leaders, their advisors, councils, and elders resolve between 80 to 90% of all civil disputes. Customary disputes resolution with elements of mediation is practiced widely in the Arctic region, North, Central, and Latin America. With the rise of secular societies in the West, mediation and the range of people acting as mediators expanded. The rise of the rule of law led nation-states led to the growth of secular intermediaries. Mediation also grew in the American and other colonies and ultimately in the US and Canada, where religious sects such as the Puritans and Quakers and ethnic groups such as the Chinese and Jewish communities developed voluntary non-state procedures for dispute resolutions. Contemporary practice of mediation. Democracy, human rights, dignity, and the growing dissatisfaction with authoritative top-down decision-making, in addition to more adversarial win-lose procedures of dispute resolution, were major motivators for a shift to a modern, formally institutionalized and developed mediation. We will start talking about North America, and then after that the rest of the world. But first let's talk about the United States in specific. In 1898, the Congress created several federal agencies to address labor management disputes. In 1913, the U.S. Department of Labor was established. And then after that, in 1926, the American Arbitration Association was founded. In 1964, the U.S. Civil Rights Act created the Community Relations Services, or CRS. Since the mid-1960s, mediation has grown significantly as a formal and widely practiced approach to a community dispute resolution. In the 1980s, neighborhood justice centers, NJCs, were institutionalized and became part of city court or district attorney-based alternative dispute resolution services. In addition to local mediation programs that dealt with different aspects of life and challenges, there are statewide programs that jumped from 4 in 1984 to 20 in 1995. Services provided by state programs included design and implementation of dispute resolution systems, training of state employees in alternative dispute resolutions and procedures, and mediation of interpersonal, group, and public disputes that involve state governments. In 1980s, the National Association of Mediation in Education, NAME, was founded. In 2000, this organization merged with the Society of Professionals in Dispute Resolution, SPIDER, and the Academy of Family Mediators to form the Association for Conflict Resolution, ACR. The criminal justice in the US and Canada have used mediators to resolve criminal complaints and disputes in correctional facilities. Family disputes is another area where mediation plays a major role. Divorce, custody of children protection, adoption, domestic violence, and so on. Models of practice in this area include mandatory court-connected programs in which disputants must try mediation before a judge will hear the case. In the late 1980s or early 1990s, there was a significant growth of mediation services and programs in the public and private sectors to mediate charges related to racial, ethnic, gender, and sexual orientation discrimination in the workplace, as well as sexual harassment, accommodation of people with disabilities, and so on. Programs have developed in several federal and state agencies and actively promoted the use of alternative dispute resolutions and mediation. Mediation has also grown rapidly since the mid-1980s in the corporate and commercial arenas. Grievance resolution systems utilizing mediation have also been put in place to promote accountability of multilateral lending institutions and to resolve disputes over economic development issues. Mediation is also used to resolve environmental and social policy issues, and it is used by federal and state agencies to develop new regulations through a process of regulatory negotiations or regnegs. One of the newest areas of growth in mediation is the healthcare industry, medical malpractices. As early as 1994 in Austin, Texas, where a majority of malpractice claims are now mediated, there was an 80% settlement rate. An emerging area of mediation practice is electronic or online dispute resolution, ODR. This form of mediation uses a fourth party, the internet, or other electronic communication system to foster discussions, deliberation, and decision-making by disputing parties. Court-based mediation programs have been established in the USA to handle a variety of issues. Mediations in this case are conducted by trained professionals, mediators, lawyers, and judges. We move now from the Americas to the mediation around the world. As we know, many non-Western cultures, especially Asia, Africa, Latin America, have lightly developed informal and formal mediation processes for resolving conflicts that are integrated into routine day-to-day interactions. Let's start our international or around the world tour by Africa. At the international level, the African Union, AU, and leaders of a number of countries have been active in mediating a range of internal, national, and transboundary disputes. At the local level, South Africa has the most extensive development and use of formal mediation processes. Other countries like Congo, Liberia, Ivory Coast, Uganda are mediating to resolve land disputes through mainly NRC, Norwegian Refugee Council. Ghana, Nigeria, Ethiopia, and Liberia are developing government-based and government-supported dispute resolution systems. Work is being done in Nigeria, Ethiopia, and Somalia to build on processes and develop culturally appropriate mediation mechanisms. Moving to Asia, China has long practiced mediation to resolve interpersonal, community, and civil disputes through people conciliation committees and court conciliation. In Mongolia, the Ministry of Justice, Gender Center for Sustainable Development, and the Asia Foundation have initiated a pilot project on community mediation. Japan has a long history of using mediation in the business culture, where intermediaries are used as introducers, shokai-sha, and as mediators, shukai-sha. Japan also has an elaborate system of court-based mediation for both civil and family cases. Korea has developed mediation to address family and civil disputes through both independent and court-based mediation programs. Thailand, Malaysia, and Indonesia have all utilized mediation in a number of areas to resolve a range of disputes. Singapore is one of the leaders in Asia in the contemporary development of mediation. It's incorporated Western and traditional indigenous philosophies and procedures that engender a kampong spirit similar to panchayat in Indian culture. Due to its religious background, Indonesia utilized its musyawara described earlier, and they introduced a mediation in environmental dispute resolution. The Philippines and Sri Lanka have developed highly elaborate community-based mediation programs for resolving civil and some minor criminal disputes. Community mediation has also flourished in Nepal. Pakistan made efforts to develop mediation, especially in the commercial sector. Bangladesh uses three types of disputes resolution. The first is the community-based informal shalish process. The second is government-facilitated shalish, with the court, or the third, which is an NGO-modified process, for example, the Madaripur Legal Aid Association, MLAA. Now, the old continent, Europe. The European Union has developed and implemented a range of mediation initiatives, laws and institutions. In 2008, the EU promulgated the directives on certain aspects of mediation in civil and commercial matters, which introduces provisions for the enforceability of transboundary mediated agreements within the EU and suspended the statute of limitations for the time allowed for mediation proceedings. The UK has a long history in leading in mediation in Europe, with practitioners providing services to resolve family, community, commercial, and environmental disputes Family mediations in the UK is unregulated. However, the FMC, or Family Mediation Council, is striving to promote some degree of standardization. In Ireland, we know that Ireland follows the steps of the UK and is a leader in the utilization of mediation to resolve a range of conflicts. The Scandinavian countries have long utilized a range of non-judicial means of resolving disputes. Private mediation in Denmark is not regulated by the state. However, the state has provisions for mediation for both criminal and civil disputes. On the other hand, in Norway, there's a long tradition of seeking mediated settlements of conflicts. When a dispute occurs, parties have the choice of taking it to an extrajudicial private mediator and process, untenrettslig medling, or to a forkligsredene conciliation board, which are available across the countries. In Sweden, there is no formal government regulation of mediation, but a list of mediators exists to whom people can refer to. In France, there's no government authority with a mandate to regulate mediation, but there are a number of NGOs that provide mediation, especially in the areas of family law. Germany is regulating mediation to address a variety of family and environmental natural resources and development issues. In 2012, they implemented the EU directives 2008/52 EWG and passed a national law to promote the use and regulate mediation. In the Netherlands, the Dutch Mediation Institute, NMI, an independent non-governmental body, has been established to increase awareness of mediation as a dispute resolution process. In 2003, the Austrian government approved the Austrian Act Law on Mediation in Civil Matters, AMA 2003, which created an advisory council appointed by the Federal Minister and Ministry of Justice to provide advice on issues concerning mediation. Since the end of communist rule in early 1990s, Eastern Europe and the Confederation Independent States, CIS, have begun to institutionalize mediation as a means of resolving a range of disputes. Dispute resolution centers in several countries have received significant assistance from US-based practitioners in the areas of training and dispute systems design. Since then, Poland, Romania, Bulgaria, Slovakia, and Russia have developed different systems and passed laws to establish either mediation councils, non-government organizations, or voluntary dispute resolution, or even approving new legislations on mediation, especially in Russia in 2011. I warned you earlier, it's a tour around the world. So arriving to Latin America, historically, members of Latin American indigenous and Hispanic cultures have extensively used mediation. In 1995, the Argentine legislature passed the Mediation and Conciliation Law. In 1996, another bill was passed, the Obligatory Labor Conciliation and Instance Law, which mandated mediation for labor and employment conflict. In 2010, they mandated the use of pre-trial mediation and made it mandatory for many cases. Brazil has moved forward in developing codes of ethics for mediators. In 2010, Brazil had the National Council of Justice, CNG, promulgate a new policy that increased the use of mediation to resolve small claims, family and criminal areas. However, there has not been a significant increase in commercial mediation. Colombia has one of the most congested legal systems in Latin America. Mediation, arbitration, and conciliation have been introduced and implemented to help address court loads. Mediation is governed by the Colombian Constitution in the Civil Code and the Civil Procedural Code and other laws. In Mexico, the new legal institutional framework also anticipated the creation of Federal Institute of Alternative Dispute Resolution Mechanisms. They conduct training and certification for its personnel and private providers support the work of courts implementing ADRs and provide orientations for potential users of mediation and conciliation. In Peru, since 1997 to 2002, USAID supported the development of alternative dispute resolution mechanisms with a focus on conciliation. Under this program, 1,500 conciliators were trained and 570 centers were opened across the country. Now moving to the Middle East, where I come from, we don't mediate, we just shoot each other. So, well, that's not quite true. But in many Middle Eastern countries and North African Arab communities, intermediary services are performed by a mediator who is a person of respect. Sometimes he may come from a group of special descent with high status. Generally, a mediator in the Arab world must be seen as someone that is neutral and impartial and of high status so that neither of the parties can exert undue pressure on him. Political groups, religious representatives, and people of special descent play a big role in mediation and reconciliation in the Arab countries. In Israel, a highly litigious society, as indicated by the millions or more cases filed in court each year, formal mediation was introduced in the late 1990s. Driven by the overcrowded count docket, mediation in the country has developed and been utilized to address a range of different disputes, especially over commercial, labor, small claims, community, environmental, and family issues. In Turkey in general has a long tradition of informal mediation within many of the communities in the country. In 2012, the government approved a law on mediation in civil disputes. Mediators practicing under the law must be Turkish citizens, have graduated from a law school, and have 5 years of legal practice. In Iran, on the other hand, the Dispute Settlement Committees, DSCs, resolve conflict between Afghan refugees and Iranian citizens. In addition to that, of course, due to the religion in Iran, the Sharia has a big impact on the way disputes are resolved, and it is very similar to the Arab countries. Last but not least, Oceania-Pacific region. Australia and New Zealand have followed a mediation development path that is similar to North America. Complaints over racial injustice are also being mediated, as well as conflicts between the majority culture and the Aboriginal people over social services, natural resources, and land issues. Australia has also a very active dispute resolution associations, the Australian Dispute Resolution Association, or ADRA. In New Zealand mainly developed mediation services to handle a range of commercial, civil, small claims, criminal, family, labor, housing, land, and environmental disputes. One of the leading private organizations in the country is the Arbitrators and Mediators Institute of New Zealand. In 2007, in Fiji, the government issued a new employment relations promulgation, which led in 2008 to the Ministry of Labor, Industrial Relations and Employment creating a mediation services unit. The unit has currently 75 to 80% settlement rate. If a settlement is not reached, the case is referred for adjudication to the Employment Relations Tribunal. Community mediation is also practiced in Fiji, primarily as informal dispute resolution process. Now, before we move on to the questions, I wanted to quote Sharon Salzberg on mediation. She said, "Mediation is essentially training our attention so that we can be more aware, not only of our own inner workings, but also of what's happening around us in the here and now." Thank you for listening to my horrible voice and for taking the time and bearing with me. Now, if you have any questions, please do not hesitate to post them online, and I will be very happy or more than happy to answer you. Thank you and have a good day.